This show. Mike, thank you.
Thank you.
Two major lawsuits against Obamacare were heard today in federal court. Correspondent Shannon Bream is here to tell us what they are and what this all means. Good evening, Shannon.
Good evening, Brett.
What about that first case? What's at stake?
Well, the first one is just a challenge by religious nonprofit groups to the HHS contraception mandate. They say this is the choice they're left with, either providing cost-free contraceptive access to their employees in direct violation of their faith, or signing off on a form that will authorize a third party to do that. They say they don't even want to do that. It would make them complicit in something they can't condone.
Whether the government believes it is or not doesn't matter. It's the believer who believes. And it's the believer who has the freedom. So it's not up to the government to start parsing religious doctrine or telling us which ones apply and which ones don't.
And today, the government continued to argue what it has all along, that it's provided this opt-out procedure, and if these groups would simply sign the forms, then, Brett, they're no longer part of the equation.
And the second case would go further?
It would, because this one is aimed at getting rid of the law altogether because of the way that it came to be. The plaintiff's attorney argued today that this originated in the Senate, the health care law did, but that it's a revenue-generating measure, and based on the origination clause in the Constitution, that kind of measure can only come from the House.
What this Congress did in passing the Affordable Care Act is plainly unconstitutional, and any ordinary person knows that the House of Representatives alone has the power to create tax bills, not the Senate.
What the Senate did was take a totally unrelated House bill, gutted it, and then dropped the health care law in. That was the vehicle for getting it passed. The government's attorneys argued today that the Senate amended the original House bill and say there's no constitutional requirement that Senate amendments be germane to the underlying House measure. Now, we should tell folks a little bit about the three-judge panel who heard this today. One was a President Clinton appointee. The other two are brand new to the bench. They were appointed by President Obama, and you may remember Mike alluded to this a little bit earlier. They were put through after Senate Democrats invoked the nuclear option, so it took fewer votes to process them through the confirmation process. Already some of the attorneys in the case are assuming they're going to lose here. They say the Supreme Court is their real goal.
Okay, we'll follow it. Shannon, thank you.